Jeff, welcome to Facebook Live. I'm so glad you could be here today.
Thank you, Brooke. Thanks so much for having me. I'm very excited.
All right. So you practice, you're a litigator, you're an attorney, but you actually practice estate litigation. But before we get into that, I should probably introduce you and tell people a little bit about you. So you do trust and estate, boutique law firm, and you're in San Mateo, which is San Francisco area, right?
Yep, just south of San Francisco, about 15 minutes by the freeway.
Okay, that's not too bad. And what you do is you really kind of come in when people are fighting over a will. Is that a fair assessment?
That is fair, certainly, or if they have questions, if there are any questions about how a will or a trust should be administered, and often who the beneficiaries should be, those are the kind of questions people bring to me.
Okay. So you're an estate administrator, you represent fiduciaries and beneficiaries. I have a funny story about a fiduciary. You guys have represented clients in hundreds of trust and estate disputes, and you've recovered over 50 million in assets. That's got to feel good.
It does, yes.
And like at the end of the day, you're just like a really smart dude.
Well, thank you. I will take that compliment and say thank you.
And this is what you do. So tell us a little bit more about estate litigation and what it is.
Sure. So whenever someone does an estate plan, it usually has either a will or trust at the center of it. And when they die, then someone, whether their executor or their trustee, has to read that document and figure out what happens next. And if the document is clearly written, then maybe they come to me and we just help them go through the process. But often there are problems with the document. It may be unclear how the trust or will should be administered, and it may be unclear who the beneficiaries are. And in those cases, if the answer isn't in the document, then you generally need to go to court. And so that's where people primarily come to me for that kind of help.
Okay. So I'll share a personal experience.
No, please.
I have a friend who is a trust administrator. And the beneficiaries of the trust didn't really understand how it worked, which, I don't know, is that pretty common?
It's extremely common, even among the people who actually sign the documents. Even while they're still living, they may not understand it. We do our best to make the language as simple and straightforward as we can, but by nature, these are cumbersome documents at times and difficult to understand.
So she's doing her job. She's the fiduciary, she's the trustee, she's also the managing partner for the partnership, all this stuff. Very complex trust and estate plan. And the beneficiaries of the trust came in and said, "You're not doing your job, we're going to sue you." Hired a big firm out of Houston to sue her. Her attorney was like, "Okay, we don't think they have any kind of cause. Like there's no reason to do this." And they called somebody like you, whose job it is to defend people in this position. And he went through and did an audit. He's like, "I have never seen anybody with such good records. And on top of that, do they not understand that you have taken the money in that trust and increased it by tenfold in 3 years? Like, what are they screaming about?" Shockingly, the firm in Houston got a little bit of information and dropped them as clients.
No,
So
that's not unusual.
yeah, having a good trustee in place is important.
Yeah, no, that would be our dream client, someone who does everything perfectly. It is rare, but not unheard of. But certainly other issues arise. I mean, if, for example, you have 4 children and you name the oldest child, or even worse, the second oldest child as the trustee.
Or the baby.
Yeah, exactly. Or the youngest. Yeah, then other children may believe through sibling rivalry and through family history that there's going to be unfairness that results. and that the trustee, simply by being named as trustee, has created an unfair situation. And so often family dynamics are as important as facts in determining whether or not other beneficiaries will go forward with a case.
Yeah. And I do want to talk about that, but I want to talk about some other things first. So you really specialize in litigation,
Correct.
but you will do an estate plan for someone that tries to ensure they don't end up in litigation, right?
That is correct. And we cannot promise anything, because if any child feels they've been unfairly treated, they could probably find a lawyer to sue. So what we do is try to create estate plans that discourage litigation and at least put the executor or trustee who survives in the best position to defend the plan. But no plan is
No
completely
plan's
immune
perfect.
from causing litigation.
Yeah, that that's certainly true. So recently I had a friend who suffered a stroke, and it has thrown her life, her business, everything into chaos. And I realized that as entrepreneurs, we have different needs when it comes to our estate plan. Do you agree with that?
No, I
As
agree.
opposed to someone who has a job?
No, exactly. I mean, business succession planning is a serious issue, regardless, if someone is simply a shareholder in a corporation. But for someone who manages a small business, that person may be indispensable to the running of the business. I've dealt with cases where a lawyer in particular passes away and has a number of cases pending, or a number of estate planning clients who are out there. And certainly, again, court relief is sometimes needed to ensure that the plan can move forward. But in the best circumstances, there is a succession plan of some kind, but it's very tricky, especially for a small business owner.
So what are things that they can put in? And you are not giving legal advice. We are simply talking about options. What are things that a small business owner should really consider when they're going in and doing their estate planning?
Well, there likely would be two pieces to it. I mean, one is that the notion of who owns the company may be something that the business owner provides for in their normal trust. Who will inherit it? It may be a spouse, but really, there may well be a succession agreement of some kind, or some other document that provides that someone with knowledge of the company or the ability to run the company may be able to continue it. But that person in turn may have to be in a position to purchase the company from the surviving spouse or the surviving heirs. So it can be quite complicated, and it does involve bringing in business counsel as well, quite often, which we do when we're dealing with corporate entities or LLCs. If we feel there's a need to also create corporate documents to facilitate a succession, then we bring in a corporate attorney, and then we create essentially two sets of documents. One is the traditional estate plan, which we would handle, and the second set of documents would involve a transition and a mechanism for transition to the next runner or manager of the company.
Well, and when you put a professional services company, throw that in there, attorney, CPA, doctor, that adds a whole nother level of problem, because unless the spouse is also licensed as the attorney, the accountant, or the doctor, they can't take over the practice. They can't inherit it.
Correct. And so again, certainly the practice itself, has value and is owned in the sense that the estate or the trust has some ownership interest in it that has value. And in that case, more typically, again, either these pre-existing agreements would exist by which the surviving manager takes over the company, but often in return for some consideration, or there are third-party brokers who sell law practices and other kinds of practices, for professionals to other professionals who then can assume the practice. So it can be quite a complicated proceeding, but it's also something that if you plan for, can run smoothly, especially if you anticipate retiring, or if you're ill. I mean, it's even more difficult to plan as a relatively young solo practitioner or professional, because there may not be someone ready to step in. It's just something to always have sort of on your radar as a possibility.
Yeah. Well, one of the things you just said that I think is key is planning.
Mhm.
And anything can go south for any reason. And you talked about sibling rivalry
Mhm.
being a great reason. But you also talk about, like, you've got 10 tips, 10 things to think about
Mhm.
to help you avoid litigation,
Mhm.
right? 10 things you can do to hopefully keep everybody out of court. Do you want to talk about those a little?
Yeah, sure. So I've given talks on many occasions to professionals, primarily lawyers, and even more specifically estate planning attorneys, on how to avoid trust and estate litigation. Essentially, part of your plan as an estate planner is to create a plan that will succeed. And nothing is guaranteed, but a successful plan is one that allows the surviving executor or trustee to move forward straightforwardly without going to court, without a lot of uncertainty. And again, you can have the most airtight plan that's clear in how it should be executed. But if one or more children, for example, of the decedent believe that the plan has treated them unfairly, they still may well be able to find an attorney who would take that on and contest the plan. And so you as an attorney, want to take your client who walks into your office and say, what are the likely outcomes when this person dies? Can I create an estate plan that will discourage contestants? And can I create one that, if it is contested, will be less vulnerable to attack, that will allow the plans of the decedent to move forward as they wished? And again, some of the things that are important to keep in mind, I mean, one is transparency. And many older clients are against this. I mean, the idea of transparency is that the estate plan would be disclosed to the kids before the elder dies. If that happens, it has some beneficial effects, such as the statute of limitations starts to run, meaning that the time that the children have to bring a lawsuit might start to run. And so you might have 4 years, for example. And so if they know about the plan for a number of years and don't bring an action,
So
that could
back up
benefit
on
you.
this.
Yep.
If you tell them about the plan
Yep.
and then you don't die for 6 years,
Yep.
it is what it is.
Yeah, it did not used to be the law, and it still is a growing area of law. But there have been cases in California over the last 5 years where a court ruled that because the contestant knew about the situation, knew about the alleged defects in the trust, and knew about the alleged mental incapacity of the person who was creating the trust, the court ruled that they had sat on their rights too long. And so it's not certain. It's what's called an equitable defense. I mean, the court looks at, well, is this fair given all the circumstances? Should this person be able to bring this action now, 10 years after they learned of the estate plan? And a court could go either way on that, but at least you have that argument then as another arrow in your quiver to say they've known for a very long time about this. And really the other benefits of transparency include, yeah, sure, go ahead.
Hold on one second. We need to break in and say, you are licensed in California. You're talking about California law. Other states may be different.
Yeah, that's correct. And even in California law, this is a growing area of law.
I work with a lot of attorneys. I got to get the disclosures in there.
Yeah, no, absolutely. No, and
disclaimers, not disclosures. Sorry.
Yeah, all of the above, But anyway, some of the other benefits of transparency, and thank you for that caveat. This is California law we're talking about. If the child is present at a family meeting, for example, and everyone hears the decedent herself tell everyone, this is what I'm going to do and this is why. I know all this sounds like a movie, but it actually has some benefit. They'll be in a much worse position because the contestant will be in a worse position. The best position for a contestant to be in is to be able to say, mom and dad made these changes in secret. Mom and dad made these changes in darkness. Mom and dad made these changes with only one sibling whispering in their ear. And that sibling took over the process. And at that time, mom and dad were both incapacitated, meaning they were mentally
Yeah.
confused, and they also were vulnerable to that child's undue influence. A lawyer has the ability to make everything happen in the open, and then you have any number of witnesses, and you even have a credibility question then for the contestant. It's like, why didn't you go to Adult Protective Services?
Right.
How
And,
can you say that you didn't understand what was happening?
and what you're really talking about is your tip number 2 is to have a family meeting.
Correct. I'm sort of merging them together, but they're each two sides of the same coin. I mean, transparency is a goal and a sort of principle. A family meeting is a mechanism by which to create transparency. Now, having said all that, the vast majority of your clients as an estate planner are going to say, absolutely not. I am not, while I'm alive, in the last 10, 15, 20 years of my life, going to listen to one of my children complain for the next 20 years about how, I deprived them of their rightful share of my estate, and maybe I'll need them to care for me. Maybe they'll be the last one standing if my kids predecease me. So most clients will say no. But if on the other hand, they say to me, well, my daughter, my oldest, is going to be the trustee, what can I do to protect her? It's like you have to choose what your priorities are. Because if you want to wait until you're dead,
you need to say, you need to bless this. This is my decision, and this is,
Exactly. So I think as a guiding principle, transparency is most important, and it's the one that your clients, especially older clients, will most resist.
I've also found, and again, this is personal experience, a lot of people don't want to talk about their estate plan because they feel like you're trying to kill them off. And
that's
it's really
huge
just
issue.
an academic discussion. Like, it's going to happen. The 2 things you can't escape, death and taxes, right? So, and that everything that we're talking about deals with those 2 issues, death and taxes. So, it's not about trying to get your hands on somebody's money. It's
Right.
just, this is what's going to happen, and you guys need to be prepared, and it may happen tomorrow and it may happen in 20 years, but this is the current plan.
Correct. And actually what you mentioned in terms of people not wanting to address the issues of what happens when they die, it extends even deeper. It's why most Americans don't have a sufficient estate plan, and a substantial percentage of Americans don't have any estate plan. And it's because, many reasons. One is they don't want to get to it and they want to defer it indefinitely, but also because it's a topic they don't want to deal with. I mean, so that's true of estate planning in general. And you're right, in terms of trying to address one's testamentary decisions that might cause conflict before you die. I mean, it's a very unpleasant situation that, again, most elderly people would rather do it in secret if they're going to do it at all. And so it's a hard sell to persuade most folks of a certain generation that this should be done in the open. And again, obviously the biggest cure for avoiding contests is again to think about the consequences for your surviving trustee. Let's say it's your oldest child. I mean, when clients come to me and say, it's time, I want to disinherit my 3rd child. And I'm like, okay, well, that's a good idea. That's interesting. Tell me about why you want to do that. And they tell me about it. And
because they forgot to call me on my birthday this year.
Exactly.
Probably not.
Exactly. It can be a huge range of reasons. And one of them may be that the person is a horrible human being who's in prison, or it may be that, like you said, they forgot to send a birthday card, or that they moved to Arizona and married the wrong spouse. I mean, these are all, issues that can arise. But I do go over with the client certain things. Like, for example, if you give your child nothing, then there is no deterrent for that child filing a lawsuit against your let's say your daughter is made the trustee and your son is the black sheep. There's no deterrent from him filing a lawsuit after you die. I mean, other than just the inconvenience of it. Given California real estate values and the value of many real properties around the country, there is money in every trust or estate, certainly in Northern California, where some of these folks, made a decent living, put together a decent nest egg, but really their house has increased in value so much that it dwarfs the rest of the value of their estate. Then suddenly you have a reason for a contest where 30 or 40 years ago there might not have been
There
one.
wasn't anything. Yeah.
Yeah. So the son sues the daughter. What are the deterrents built into the document itself? In California, we have something called a no contest clause. They used to be quite powerful, meaning that if son files a lawsuit to contest the trust, he would get nothing, and that would be true most of the time. Now they're narrower. Now he would have to file a lawsuit without probable cause. No court has ever determined what that means. The statute says, well, if given the circumstances, a reasonable person would find, that if they do some more discovery, that it's reasonable to proceed. It's so vague that it
Yeah.
doesn't serve as much of a deterrent.
Well,
But
there is a family here in Fort Worth, and the son said that his mother was not being a good trustee. And the Texas Supreme Court said that he was challenging the will. And he kept going, no, 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 no. I'm not challenging the will. I'm challenging her fitness as the executor. And they still shut him out completely.
Yeah, no, it varies greatly from state to state. And again, historically in California, up until around the 1990s and early 2000s, challenging the acts of a trustee could be a contest. And then they determined that, or at least the legislature found that created too much opportunity for trustees to create mischief and to mishandle trust assets. And so the legislature began to chip away and create exceptions. Yeah, and so that's no longer a grounds for a contest. In California now, not to leap deep into the technicalities. I mean, most contests.
All right, well, let's not go deep into the technicalities.
Yeah, most contests are to throw out the will or trust, and that's the contest. Now keep in mind though that most no contest clauses, even the most well-written one that's completely compliant with the law, they fail because unless the settlor, unless this person in your office is willing to give a decent sized gift to the son. I mean, let's say you have $1 million estate and you give the son 0. Well, if he files a contest, he will get 0. If he doesn't file a contest, he'll get 0.
He'll get
so
zero.
That's completely useless.
He has nothing to lose.
So you have to determine how big the gift should be. If you have $1 million estate, it probably has to be $200,000 or $300,000 to really deter him. Maybe 100 will do it. But again, most clients are extremely reluctant to do that. They're like, no, I'm not going to do that and I don't want to. And then I just circle back to, okay, well, it is your daughter who will be sued. But these are your considerations and I understand them.
All right, let's get back to the list. So there are 10 things. So you talked about full disclosure. You talked about how to do that. Your number 2 is through family meetings. You skipped ahead a little bit and talked about no contest clauses. But I want to go back to something you said, because you've got a number of things that kind of feed into this. So you talked about a lot of people want to do this in the dark. And I think your next tip about witnesses kind of helps with combating the darkness.
That is correct. I mean, the first and foremost witness to a well-executed trust or estate plan is going to be the attorney who drafts it. And the court is instructed by the legislature and by case law that you give the most deference to that attorney, because that is the person who has an ethical duty to establish that the client in front of him or her has mental competency and is not being subjected to undue influence. And often that attorney will be one of the witnesses to the will or the trust and say, this person, to my knowledge and based on my observations, is not incapacitated and is not subject to undue influence. So that's one thing that going to a good estate planning attorney can help ensure. And the second piece of that is that a will normally has 2 witnesses. Often it may be a paralegal or a second attorney in that attorney's office, but it may also be someone who is trusted by the decedent and knows the decedent well and can testify, she told me over the years this is how it was going to be. So choosing a witness can be important. and witnesses are crucial in defending a document that may have some questions around its legitimacy.
That's awesome. And that kind of leads us to the next one. You said something about their mental capacity.
Yep.
So what's your next tip?
So the next tip, and this is something that you advise your client, and I'm using the words testator and trustor sort of interchangeably. A testator creates a will, a trustor creates a trust. But your client comes to you and is 90 years old, and you might suggest to the client or advise the client, that you may want to consult with your physician and get a clean bill of health, essentially. The physician may not be a neurologist or a neurobiologist or a psychiatrist, but they can at least ask you some questions. They have what's called a mini mental status exam that they can give to a client, or they can just ask questions that determine if the client is oriented to person, place, and time. Meaning, do they know who they are? Do they know where they are? Do they know what time it is? These are questions a physician can ask, and a physician can make a determination even in a brief meeting.
So it's
that could
just
help
kind
you.
of one extra thing, so
Right.
that if the child or whoever is trying to contest it says, oh, no, they weren't mentally fit, actually went to the
Right.
doctor and checked. That's
Right.
awesome.
Mhm.
All right, so let's talk about your next one. What's the next tip?
So taking good notes is important for an estate planning attorney. It may be that you create an estate plan and that person, God willing, may live 30 more years after you do the estate plan. And so if someone comes to you and says, where is your file? The rules in California are that your file while your client is living, is privileged and can't be produced. But after your client dies, a court can order all of those documents produced. And if you've kept good notes of your interviews with the client and a description of your perception of the client, and again, if you as an ethical attorney have made the determination that this estate plan is appropriate, that the person has their capacity, and that they're not being subjected to undue influence, your notes should reflect that. You should even have some factual observations that show why you came to that conclusion. So then 30 years down the road, if your deposition is taken or you're sitting in a docket at trial being questioned, you have a set of notes to refresh your recollection.
But that's probably also a good thing for the client to do also, is to keep some notes and keep it with a copy of their will, so that if let's say their attorney predeceases them, there's still like a little bit of work product. There's still, you can see, no, don't like this because, and stuff like that.
Now, documentation is very important. I mean, if the testator has a set of beliefs that are informing their decisions, for them to write a letter to include with their estate plan could be tremendously helpful, especially in their own handwriting. Even if it is not itself an estate planning document, it can help show what they think or what they feel. Now, keep in mind, as a litigator, I look at all this and say, okay, well, then we will allege or assert that the bad daughter unduly influenced mom to create this letter.
Oh my gosh. Let's not go too far down that path.
But having said that, the more documentation you have, the better, so long as it supports that this person has capacity and is not being subjected to undue influence, meaning that someone is not coercing or manipulating them to create this document.
All right. Now, interestingly, in your next tip, it talks about documentation, but in a thing that most people think you should do. Tell us about number 6.
So you will find in many practice guides that videotaping a testator or settlor when they're doing their document, can support later after they're gone the notion they had capacity. And my tip I describe as don't go to the tape, but I think more precisely what I mean to say is tread carefully. I had one case where a decedent was quite elderly, maybe in her early 90s, but remarkably articulate and sharp. And the attorney, as a result, in this videotaped meeting, was able to just sit back and let her describe what she wanted to do and why. And then at the end of the tape, she signs the document. That is, a perfect tape. That's great. If you have that, you're in good shape. That case settled. I was representing the beneficiary named in the document, and a stepson had brought a lawsuit. And it ended up settling with him dismissing the case. As you described before, it was just a case that couldn't go anywhere,
Yeah.
which doesn't stop everyone, but it did stop him.
Yeah.
Having said that, I've seen many other videotapes where the decedent, again, is quite elderly, and he or she may be well spoken and able to express themselves in an informal conversation like this, but they also may not be. I mean, it can be a very artificial situation to tell someone, especially an elderly person, I'm going to videotape you now. I'm going to ask you some questions. I want you to answer them and be casual and conversational. That many people freeze up. And if you make a very bad video recording, that is discoverable. If you make a bad video recording and you destroy or erase it, you may later have to answer. Yeah, you've destroyed evidence. And so, you have to be careful and be sure this is right for this client. And if the client's going to appear tentative, and if you have to tell the client, this is where you'll sign, and even a competent client really wants to sit back and let the attorney guide the process. And that's where there's a danger in these sort of videotapes where it's like, okay, where do I sign? You sign there. I mean, you want to make sure, if you are going to do a videotape, and as I said, I have mixed feelings about them at best, you really want the decedent to be able to just speak openly about what they're doing and why. And you don't want to have to ask them leading and directive questions. But most videotapes I've seen fall into that trap.
And you really don't want the one that makes the joke of, I don't even know what I'm signing here. I'm just signing. Golly, that's
I
gonna kill your
heard
case.
Audio recordings like that, and yeah, it can go disastrously wrong.
All right, so we actually have already covered your next tip, the no contest clauses.
Yep.
So what's the one after that?
So the next one is avoiding contributing to the presumption of undue influence, which is a lot of big words. But as an estate planning attorney, you in some ways are the gatekeeper of this estate plan. I mean, the client's walking into your office and you want to create an estate plan that you are certain is the product of that client's wishes and not the product of someone else's wishes. The best way to do that, let's say you have an elderly client who comes in and she wants to bring her son into the room. And you ask the client, well, who's going to be the primary beneficiary of this trust? And if she says your son, then you have to at least advise her, well, that's a really bad idea. I'm going to tell you why. If your daughter, for example, who you're disinheriting, if she comes later and says, it was my brother, he manipulated the situation, he made all this happen. Mom would not have done this except for his influence on her. You're not going to want the brother in the room. You want to be able to say, nope, that's not true. You want the attorney who drafted the document to be able to say, it was just me and mom. I asked her the questions. I was very comfortable. This is what she wanted. Son was nowhere to be seen. It's a clean document. It's still not a perfect answer, but that's something where you as an estate planner have the power to insulate the document as best you can from allegations of undue influence by allowing the son into the room. And keep in mind, many elderly people want this. They're like, I'm not comfortable. You, Mr. Attorney or Ms. Attorney, are a stranger. My son takes care of me all the time. He's always there for me. I trust him. I want him here. I personally have not done an estate plan in those circumstances, but I know attorneys who have, because they say, look, this person needs their son there as their support. But to me, it impairs the process and creates a vulnerable document.
Awesome. All right. The next one kind of comes back to those disqualified beneficiaries.
Exactly. So in California, as everywhere, but in the late 90s and early 2000s, it was recognized that more and more elderly people are finding themselves in a position where they don't have family nearby, or even if they do, where they're relying on paid caregivers to provide their care. And so this section says to beware of disqualified beneficiaries. And the legislature has passed statutes that say that if someone is your care custodian, your day-to-day caregiver, and they end up being a significant beneficiary of your estate plan, that you as the attorney or you as the client should be aware that that person's gift is so vulnerable that unless they can prove that it is completely the product of the testator's wishes, then the court will throw it out. I mean, and so what they've done is create further.
So second cousin Lucy's daughter's whatever can contest it.
Correct.
Who may not have seen, Aunt Sally in 40 years.
Exactly. If Aunt Sally dies with no nearby close family and yet has a document that gives everything to her caregiver, then there are heir search firms who will search out distant heirs who may inherit if the will is thrown out, and they'll bring that lawsuit.
Okay, but this is not the same. If you get an email from this company, it's not the same as the one that says I'm a Nigerian prince. If you give me money, I can get my throne back, right?
I suspect that that many people see emails from heir search firms and have exactly that response. But some heir search firms have legal legitimacy. One could question whether a distant cousin from West Virginia should inherit Sally's San Francisco house when they've never met, and in fact their parents and grandparents never met. But that is the law if she's left without a trust or with any other heirs. So yeah, anyone can come in then and challenge the document. So what the legislature did is it creates a situation where an attorney can do a second document called a certificate of independent review that says, I've reviewed this, it's not the product of undue influence, it therefore should not be thrown out. That document doesn't prove the instrument is valid, but it's very good for the caregiver who then can present it to the court and say, see, I don't have the burden, it's still that distant cousin who has the burden. And that's really important in these cases, is whoever has the burden of proof may win the case because the decedent is gone and cannot testify one way or the other. So there are protections built in. What's even better, if you do this certificate of independent review as an estate planner, what's better than that is if you turn it over to another attorney who then meets with the decedent and determines that it is her wishes to do this, then it makes even a more well-protected document. Now, again, the problem for a client is that she will say, well, do I have to pay 2 attorneys then? And the answer is yes.
Yeah.
And it's a cost benefit. If she wants to protect the gift to her caregiver, and again, the caregiver may well be crooked as the day is long, or the caregiver may really be the legitimate natural object of this person's affection. You just don't know. And that's why the law looks so critically and carefully at these documents.
Awesome. All right. And your last tip for staying out of court is?
So in California, you have to be especially careful when you're representing a client who may be incapacitated or vulnerable to undue influence. And in many states, and this is what the American Bar Association has recommended, if your client comes to you and in your meeting with your client, you determine that your client is being manipulated by someone, that she is, being unduly influenced by someone, you can call the Adult Protective Services, you can call health authorities, you can call legal authorities. In other states, you can do that. In California, you cannot. In California, the information you receive from your client is privileged under the attorney-client privilege. And so you can make a decision as an attorney whether or not you are willing to do an estate plan for that person. But what's very unfortunate is that if you say no, and if the caregiver or the bad son then wheels, mom or dad out of the room and goes to the other attorney down the street, there's not much you can do about it. In other states, if you believe undue influence is going on, you can try to take some action to prevent it. Here in California, it's quite narrow what we can do. And one exception is physical abuse. I mean, if an elderly man or woman comes into your office with a black eye or reports to you that they've been neglected or physically harmed, or that there's a threat of physical harm, then you absolutely can report it to authorities. But if you believe financial elder abuse is occurring, you really are quite limited in what you can do. And it's actually, in my view, outrageous. I understand some of the policy reasons. So you just have to be very careful how you handle it. In general, my advice to most estate planning attorneys is if you have these concerns, then you cannot sign a document that says I don't have these concerns. Yeah. And But it's tricky again, because people want to be able to do estate plans for people who come to them. It's a public benefit
Right.
that an elderly person can make a gift as they wish, and not to some child or other heir that they absolutely don't want to give it to. But it's a very careful balancing act. And again, part of my job is to defend estate plans, knowing that they may be vulnerable. And it's a very tricky place to operate sometimes.
Awesome. All right. Well, Jeff, I appreciate this. I think you've given people a lot to think about.
Well, thank you, Brooke. It's been a
So,
pleasure for me. And definitely, I mean, everything I've said here is general by nature. And any questions that anyone has, they absolutely should go to an estate planning attorney to discuss their concerns and some of these issues. It's not enough to make assumptions. I mean, it definitely is very important to have good counsel to help guide, clients through these situations.
well, and I think more than anything, what I've taken from this is plan early, plan often, right?
Absolutely,
Get it
absolutely.
in place, review it on a somewhat regular basis. Tax laws change, your
Mhm.
circumstances change, but the earlier you get it in place and the more you communicate with people what's happening, the better off everybody is.
No, it's absolutely true. That's very good advice.
Awesome. All right. Well, thank you so much, Jeff. I really appreciate you joining
No,
us
thank
here
you, Brooke.
today.
It's my pleasure. No, we will talk soon. Thank you so much. Take care.
Bye.
Bye.